Hi, my name is Gayle O'Connor, and I am here today with Craig Ball, who happens to be a special master in e-discovery and also a professor of law at the University of Texas. He teaches e-discovery there as well. Thank you, Craig, for your time today.
Pleasure, Gail. It's always a pleasure to do one of these with you.
I am so excited to talk about this today. We are going to be talking about the latest Primer on Social Media, second edition, put out by the Sedona Conference working group. And it is actually a primer for comment. And you have plenty of time to make comments after watching this video through September 10th of 2018. And I'm sure after you hear Craig speak today, you might want to take a look at it. It is about 58 pages long, and Craig has studied it feverishly. Correct, Craig?
Yes, my fever is broken, however. Thank you.
Yeah, right. You probably fell asleep reading it. No, I'm kidding.
No, I thought it was actually quite interesting.
You know, so did I. I thought it was really interesting. So I'm really excited to get going today and find out what you think about it, and a couple other questions for you. But that is my first question: is tell me your overall feeling of the primer. The first one, as you know, was written in 2010 or 2012. I'm sorry, and it was definitely time for a new one. And I'm jazzed that it's out there. So what's your take on it, Craig?
Well, I haven't reached the level of jazzed, but before I do talk about what I think about it, Gail, forgive me if I'm lawyerly for a moment and share a disclaimer. I'm a member of Working Group 1 of the Sedona Conference, and we have a rule at Sedona that what happens at Sedona stays at Sedona. So I want to assure my Sedona listeners that I was not a member of the committee responsible for drafting this publication. So nothing I'm sharing today is breaking the Sedona omerta of silence here. So going back to your question, what do I think of it? Well, I was pleasantly surprised. Some Sedona publications in recent years have disappointed me with their lack of balance. They seem to have come with an agenda. And for the most part, I thought this was a very high quality document. I thought it was carefully thought out, very current, useful in its structure, very accessible. And I thought that the points that they made were tremendously balanced for the most part in terms of the interests of requesting parties and producing parties. So that was a very pleasant surprise for me, Gail.
Well, you know, when I went through it as well, I thought not only had they updated so much of it with respect to the new federal rules, with respect to the ABA, guidelines on attorneys' technical competence. They addressed that as well. They even addressed the GDPR. I was very, very impressed with how they included everything that is going on these days. As you and I both know, social media has become a hotbed of information for e-discovery. And that's what we're primarily going to be talking about today, since, well, you are the e-discovery guru. Well, along with Tom, my husband, of course.
Of course.
So I wanted to ask you, all these family law attorneys are wanting to look at people's Facebook pages, and people are deleting things. And we've even got lawyers out there telling their clients to delete things. And this paper addresses all this. What are your thoughts about the role of social media is playing in e-discovery these days?
Well, I think social media has certainly started in the areas where we would expect it to be, most prominently in matters of personal injury and matters of family law, situations where peeking into the content of people's personal lives, their ability to engage in certain activities, their attitudes, their mental status, their misbehavior are going to be fair fodder for discovery in an effort to keep down personal injury damages, or perhaps show improper motivations, unsafe conditions for child custody, and so forth. But I think we're seeing social networking as a source of evidence creep into a great many more facets of litigation than those obvious ways. We're seeing promises made in connection with products. We're learning about events by virtue of Facebook posts, tweets, and so forth. Certainly, we currently have government by tweet in certain respects, and I don't mean to get political here, but I don't think I'm surprising any of our listeners.
You are certainly not surprising me.
Yes, well, by mentioning the role that tweets have taken in both public forums and in public issues. I also want to point out, Gayle, that rather surprisingly and interestingly to me, this primer didn't just stop with traditional forms of social media, Facebook, Twitter, Instagram, LinkedIn, and so forth, but also encompassed messaging as a source of electronic evidence. I cannot emphasize enough how important I think the role of messaging is as a routine and essential aspect and source of discovery for communications.
I certainly couldn't agree with you. Sorry for interrupting, but
Not at all.
I can't agree with you more. And people don't realize that messaging is available as something that can be discoverable. And what's interesting about the paper is it literally starts out with the messaging app, showing its importance as far as I'm concerned in the minds of the working group of the Sedona Conference who put this primer together. Do you agree with that?
Oh, absolutely. Messaging and mobile have largely eclipsed email. I think the main reason we continue to focus so much on email and electronic discovery is more a function of tradition and established procedures than it is a real-world assessment of where the most relevant information lies. We've seen double-digit diminishing reduction in the number of email transmissions for business compared to the double-digit growth in the use of messaging. And so if we're still looking at email as the place where the most revealing, unvarnished, unguarded communications occur, we're missing the boat. That information has moved very much to messaging. And I think that point, while not made explicitly in this primer, is a situation where it's great that they are opening the door to showing the viability of that recovery. And there's some useful case citations in the primer that make it clear that there's really no fundamental difference between your right to get to the content of mobile devices, social networking, and messaging than your right to get to email and loose documents stored on computers and servers.
Well, you know, when you just said that the rate of decline in emails comparative to the rate of, you know, incline in social messaging, I was not aware it was that drastic. I've done some research as far as how many messaging apps there are and who's using what. And here in the United States, most people use the Facebook Messenger app, but all over the world, WhatsApp is a huge messaging app. And I believe that WhatsApp is starting to get more play here in the United States. Do you believe that as well?
I think certainly for those who have cross-border relationships, they're much more likely to turn to a platform-independent application like WhatsApp. But we're seeing messaging in many quarters. Messaging is obviously built into some Google tools. Messaging is built into some Microsoft tools. Skype supports messaging. You mentioned WhatsApp. We have Apple's iMessage. So, and not to mention, of course, the basic SMS and MMS messaging apps that are ubiquitous in mobile. I mean, even if you are a person who likes to play words with friends, you have a built-in messaging app at your disposal there. I've always wondered if we might see in a spy novel or some kind of real world espionage or terrorist activity that turns out they use something like like words with friends as a means to communicate, because
Oh my God.
that methodology is not on most people's radar.
Wow. I mean, now we're talking super spy stuff.
Well, or just someone who wants to be a little bit off the grid and frustrate those who might want to look. I mean, it might not be a super spy. It might simply be a broker who's wanting to use inside information from a source and decides to use it on words with friends instead of through the brokerage firm sanctioned methodology. So there are a lot of ways this can go wrong, but I don't want to spend too much of your time, Gayle, talking about the messaging aspect. I wanted to come back to social networking. I thought this paper did a good job of, as I say, not only identifying the various channels of social networking and categorizing them in useful ways. Because in order to be able to talk about these things, we need to be on the same page in terms of what we call them. And they've done an excellent job in the kind of glossary introduction that they provide. Now, what I mentioned earlier, the balance. And I thought, why are they being so balanced? Why are they making it clear that there's no impediment in any meaningful way to being able to demand, require preservation of social networking content, get it produced? And then I realized, well, the reason for that is because I think those who are thinking about social networking as evidence are thinking that it's something they're going to get from plaintiffs, essentially, from
Right.
individual claimants. And so naturally, if one has a corporate point of view or a defensive point of view, you want to be as free in being able to collect information that may prove prejudicial or help with the cross-examination of individual claimants. I noted that when they came around to corporate social networking or social networking more particularly that needed to be preserved and obtained from employees, that all went by the wayside, and suddenly the attitude seemed to be, oh, corporations can't require their employees to preserve or produce social networking. So the ox was getting gored differently at that point. Well, we can talk about that again, but the bottom line is, I thought this was a very well-written piece, definitely worth the time of everyone in eDiscovery to work their way through it, and I think begin to use it as a framework for discussing the issues we need to address in Meet and Confer, in putting together preservation protocols, and in propounding requests for this type of information, as well as looking to what our options are to preserve and to review this information. It is challenging. We have been trying to put a square peg into a round hole in dealing with messaging and social networking because there are essentially no purpose-built tools for review. And I think that's got to change. And I think this primer is a worthwhile step toward effectuating that change.
Wow, that's some great information.
Thanks.
It's just great information.
Thanks.
Let me ask you this. What do you think, if anything, is missing from the primer? Is there any part that they didn't cover? Because you've been going into so much of what they did cover. Do you think there is some room for improvement, so to speak?
Well, there is, and I need to take advantage of the public comment period, as you encouraged everyone to do, to read it and share their views. A couple of things. I thought they gave short shrift to the issue of preservation when it came to entities. They took the position that basically the legal control test should take precedence here, not the practical control test. And for those who are not familiar with those expressions, they go to the issue of a right of control for purposes of being required to preserve and produce information. The legal control test looks to imposing that right only on those who have the legal right to force preservation and force turnover, versus the practical ability test, which speaks to going to the limits of your practical ability, your genuine real world ability to persuade people to preserve information and make it available. The Primer pretty much dismisses the practical ability test and instead just says, well, information, the control of your employees and their social networking sites is not in the corporate control, therefore you basically have to do nothing. I disagree with that. I think that's at odds with a fair amount of both case law that is out there and the attitudes of judges and those of us somewhat steeped in this area, where while you may not have to be a guarantor or to ensure that your employees will necessarily preserve and produce, it is probably wise and very likely obligatory that you use such influence as you have. You may not be able to say to an employee, if you don't turn over access to social networking or preserve it, that you're fired. That may run afoul of other issues, other regulations. But certainly to send out a notice to employees that if they are holding information on their social networking repositories that may be responsive or relevant to issues in litigation involving the company, that the request is made by the company that that information be preserved and it may be turned over. That I don't think that is asking too much of a company, and I think it falls squarely within their reasonable ambit of obligations. Now, the employee may choose not to listen. You may not be able to force them to comply, but the failure to advise third parties who are so much subject to your influence and control, I think that was given insufficient attention in the paper. And so I realize that that's something that I think a more balanced approach is needed. Then I think
I was going to say what else, because that's really interesting.
When they talked about preservation, I don't think they gave sufficient attention to the issue of search. There was good discussion of the various methods that are available today to preserve social networking content. And one of those that was touched on is one of the most frequent used today, even though it's largely inadequate, and that is screenshots of social networking sites. Now, I'm not trying to say across the board there's no place for screenshots. Certainly where you have a very modest amount of content and the screenshot can provide a reasonably usable and complete preservation of the information and production of the information that is relevant in the site, it may pass muster. But I think we know that screenshots do a rather poor job of providing utility. They kill all the linked information, any nested information that you have to expand in order to see. And we see that with, say, comments on Facebook posts on a user's wall. Unless you've expanded previous comments and painstakingly go down and take a shot of each page, it's very easy to miss potentially relevant content. So what I would advocate is that they talk about not just the problems of getting the information when we talk about screenshots, but the more severe problem of being able to electronically search that information. You cannot electronically search static screenshots. And so that's a compelling reason to use alternate forms of preservation or supplement with other forms of preservation. And while later they do a pretty good job of talking about those issues, when they talk about it in the context of preservation, I thought they overlooked the need to talk about preserving searchability, or shall we say at least did it in somewhat of an elliptical way that I think they would do well to address it more head on.
Interesting. Now, I know that there was a company, Social Evidence, because I worked for them, and we were trying to be, it was a startup company, and trying to gather, authenticate the evidence for court. But to my knowledge, there is not another company out there right now, and I could be wrong, and if I'm wrong, please let us know, that has any other way to gather the data other than screenshots. Is that true?
No, that's not true. In fact, in one of the footnotes of the primer, there's a discussion of a tool that's been around for a number of years called X1 Social Discovery. It's a multi-$1,000 tool for an annual license, and it's been $1,500 for some years. Somebody has told me recently it's gone up from there. So I don't know. Don't trust me on price. But it's a tool that is designed to collect from a variety of different social networking sites and to authenticate the pieces that are collected using hash authentication. So there are not many tools that are purpose-built for collecting social networking. Certainly there are a number of tools out there that are purpose-built for preserving messaging. There are excellent takeout tools available for preserving Google content. To a lesser extent, and without authentication, you have some of the social networking service provided archival tools, much like Facebook provides a way to repatriate much of their content. Twitter allows you to collect your tweets over the life of your tweet account. And while each of these have some shortcomings when it comes to a perfect or forensically sound collection, most all of them are better than the complete failure to preserve that we see occurring routinely today.
Right, right. Well, I don't think I have any other questions, but do you have any final thoughts on this primer? And how can we encourage people to get comments in? You did say earlier that you would encourage anybody, litigators particularly, to make their way through this primer. How can we encourage people to make their way through this primer and make comments so that we can make this the best, one of the best tools for litigators out there today?
Well, first, I would suggest that they go to thesedonaconference.org, thesedonaconference.org, and know that these publications are free. They may have to give a little bit of information, and certainly they'll have to agree to the Sedona policies for usage, but it won't cost you anything to get hold of this. It's a well-written, engaging piece. I'd like to see everybody read it so that we'll begin to have a common nomenclature, a common argot, lingo that we can use to discuss this at meet and confer and at planning conferences and amongst ourselves at conferences in laying out the challenges. When this information is relevant, and it is very often relevant, we have very little ability amongst ourselves to talk about how it can be preserved and how we can assure a level of trust in the process. I've seen many misbegotten efforts where one side tries to get the credentials to get into the account of an opponent, and I just cringe when I see that for a variety of reasons. One, because it's tantamount to asking to rummage through people's desks and cabinets in the old days.
Totally.
Right. And it's just simply, it's the definition of a fishing expedition. But two, it's problematic because when you log on as an individual, you put yourself in the position of being accused of spoliation using that access or alteration. I think it would be a dirty trick to give someone that access, because it would equip you to pretty much attribute anything missing or any other problems or anything you don't want to own up to the allegation that it was put there or altered by your opponent. So please, listeners, don't ever do that. If you must do it, use a neutral to do it. But do not put yourself in the position of standing in the shoes of an opponent and having their credentials, not to mention the risks associated with those credentials possibly serving as keys to open a lot of places where your opponent should not have the ability to go. More importantly, Gayle, lawyers need to read this because increasingly courts are saying to lawyers, it's your job to look at what your clients have in social media, to assess its relevance, and to keep the process above board, not delegating to your interested client the ability to choose what they will bring forward or not, which is very often an untrustworthy process, that custodial directed process.
Right, right.
But instead, working collaboratively, where when a lawyer says to the judge or to the opponent, I personally went through the site on this day or these dates with my client, I satisfied myself that the information that was present, that was responsive to the requests, was preserved, was pulled out, and will be produced to you after an appropriate review for relevance and privilege. I think a lawyer needs to put some skin in that game. Right now, lawyers are just using their lack of technical ability, shameful as it is, and increasingly in violation of professional responsibility obligations, interposing their ignorance as a means to let the process go south. And I'm grateful to those courts who are calling attorneys on the carpet, not just those who have foolishly and otherwise said, clean up your Facebook page, delete that, but those who have just abdicated their obligation to meet their duties in ensuring that a reasonably thorough search and assessment has been made.
Boy, I've seen that in person. I've spoken at conferences, and after I've spoken, I've had attorneys come up to me and actually say, you mean I wasn't supposed to tell my client to delete stuff off his Facebook page? And I just am lost as to what to say to them.
Well, let's talk about that for a moment if we have it, Gayle, because it's an important issue and it
Sure.
gets a little lost in the process. It's spoliation and probably attorney misconduct if you tell your client to destroy data or to remove data from a public-facing page in a way that that data is not preserved. I personally do not regard it as malpractice for an attorney to say to a client, change the privacy settings on your Facebook page so that only your friends can see your content, but do not destroy it.
Right. I completely agree with that.
There's not an obligation to make social networking content public, but there may very well be an obligation to preserve it if it is potentially relevant to anticipated litigation or disputes. And that's an important distinction. Closing off or even removing content from a Facebook page is not, in my judgment, a problem so long as you've taken appropriate steps to preserve it so that its full content and its searchability can be reestablished if need be in the litigation.
Right. If it proves to be relevant, or something that's necessary for the courts.
Right. You can probably even delete it after you have fully preserved it, because there's no obligation to keep multiple copies. And again, as I say, no obligation to keep your data public facing, as long as you don't lie about what that content was or whether it pre-existed on the site when questioned.
Right, right. And it's interesting because I'm going to be doing a session out here in Louisiana for the Louisiana State Bar Association on securing your Facebook account, your Twitter account, your LinkedIn account, so that outsiders cannot see your information. And I'm aghast at how many people friend request me, and I go to their profile to see what it is, who they are. Do we have common friends? Do I know this person? And their Facebook page is completely open, and I'm just aghast at that, at how often I see that. But it does boggle my mind that if you're going to be using something like Facebook or something like Twitter, that you don't lock down your account as an individual. But that's a topic for another day.
And it's a topic that's not security, but the issue of ethics, a topic that's also touched upon in the Primer. So if you'd like a quick and dirty exposure to the issues of lawyers and social networking ethics, it's another good reason to read the primer.
Right on. I so thank you for your time today. And as far as comments, the way that you can make comments is simply by sending an email to comments@sedonaconference.org. And as Craig mentioned, the paper, the primer is primer, whichever side of the fence you're on.
Potato, potato.
Potato, potato, tomato, tomato, whatever. It is available at no charge. And you can actually go back and see the 2012 version as well. It was a 2010 or 2012. The first
I'm
one.
sure it was one of those, but I don't know off the top of my head, Gail.
Yeah, I've got it in front of me, but of course it's not coming right to my.
And you said SedonaConference.org. That may be right, but I know it to be the SedonaConference.org.
Well, the actual email for comments is comments@sedonaconference.org.
Gotcha.
So,
okay, so if you're going to the site, it's the SedonaConference.org, but you're saying if you're going to email, it's just SedonaConference.org. They might have both of them, Gail, so I don't want to confuse. But
and that information is in the primer. So once you go to the primer, you can easily see the URL or the email for making comments should you so decide to do so.
Excellent. I suspect both of them will go, at least this URL, both of them will go to the Sedona Conference. Yep. And
Google
this is
Conference
working group number 1.
Yep.
So if you're looking for it, working group number 1 for the Sedona Conference primer on social networking.
Sedona Conference primer on social media, second edition.
Excuse me, you're right. You're right. See, this is why we have to get our nomenclature straight, get our lingo down.
That's right. That's right. Well, Craig, I want to thank you for your time today. And I've got massive rainstorms and thunder happening outside my house right now. And I can
see it behind me. You can see the raindrops in the pool, I expect.
The raindrops in the pool. You should go swimming in the rain.
No, I'm going to go singing first.
Singing in the rain. Okay, Craig, I so appreciate your time, and I can't wait to see you again. And have a wonderful afternoon, and thank you to our audience for staying with us today. Craig, thank you again very much for your time.
Thanks, Gail, and thank you, listeners.
All right. Everyone have a great day, and we will see you next time on the eDiscovery channel.
Bye-bye.
Bye-bye.